the common mistakes that families make as loved ones age. And as always, for those of you who have seen this presentation before, I think there are a couple of you out there who have, I always start with these guys. And these are the Rolling Stones. So you look at these guys and you ask yourselves, well, why is an elder law attorney showing me a slide of these old rock and rollers? Because yes, they're old. You know, as a matter of fact, now that I'm looking at this very closely, look at Keith Richards' fingers. He is suffering from arthritis. He's the lead guitarist, one of the best guitarists in the world. But the reason I'm showing you this is because these gentlemen are old. They're not really old. For an elder law attorney, they're actually not old. But in general population, these are 78. I think Mick Jagger might even be 79 years old now. They're still out there. Yes, they have personal trainers and nutritionists, and they're very wealthy. These are individuals who will never have a problem affording healthcare. But it just goes to show that our population is aging. You wouldn't have seen individuals like this 40 or 50 years ago still performing at this level. Then there's this man. And normally I ask people, who is this? Most people get it right. It's Paul McCartney. And he wrote a song a long time ago. Will you still need me? Will you still feed me when I'm 64? And he's far surpassed 64. He's pushing 80 now. And once again, he will not be needing government benefits. He has no problem affording the finest healthcare or long-term care that he may need. But it once again goes a long way to showing that our population is aging. We have a lot of seniors out there. So by far, the biggest mistake that I'm finding people are making, and it literally, it astounds me. We're talking about this in my office on a weekly basis with people. People are either calling and saying, I've already done my planning for the future because I've given my largest asset, my home, away to my children, or they're asking us merely to transfer their home to their children. This is potentially a devastating mistake. I put the mistakes in two columns here with when we're talking about transferring a home or another large asset to individuals. And these two buckets the first bucket is the problems that you will definitely have. The second bucket is the problems that you may potentially create. So in the first bucket, we have the problems that you definitely will have. Most seniors that I've encountered have been living in the same home for 40 or 50 years. They've often raised their families in those homes. And thus, especially in New Jersey, on the East Coast, there is a large appreciation in that home. So as an example, an individual or a married couple purchased a home for $50,000. Now it's worth $550,000. So there is a $500,000 capital gain in that home. If they sell that home while they're alive, why would they sell the home? To downsize, to move to assisted living, or to move to a skilled nursing facility. They, along with everyone else, will receive a $250,000 capital gains exclusion so long as they can show that it is their primary residence. And their primary residence simply is defined as the residence that they live in for 2 of the last 5 years. They get a $250,000 exclusion if they're single, a $500,000 exclusion if they're married. If they give that house away to their children while they're alive and must move out of that house at some point, their children cannot take advantage of that capital gains exclusion. Thus, going back to my example, if there's a $500,000 capital gain in that house and the capital gains tax rate is 25 to 30% between state and federal, there's going to be upwards of a $150,000 tax bill. Big mistake. Likewise, in that same bucket, when we pass away, our heirs get what's known as a step up in basis. Basis is the cost of something. So if my mother, for instance, were to pass away in her home, she would, the cost of the home would not be $50,000 to her heirs. The cost of the home would be that $550,000 in my example. Thus, there would be no tax due because $550,000, they sell it for about $550,000. There's no gain. But if my mother gave me the house during her lifetime and then passed away, when I sell that house, I am going to inherit her cost basis at the very best. And once again, it could be a $150,000 tax bill. So that's a big mistake. And that's a mistake that happens over and over again. Then, of course, there are the potential issues that this could cause. You give it to your child and your child gets divorced. Well, the divorcing spouse may seek that asset as their own, or they want half of it. The child passes away before their parent. Then that house goes in accordance with their will, or if they don't have a will, in accordance with the laws of intestacy. That child runs into financial problems and either must borrow against the house or has creditors attaching that asset. And as a matter of fact, that happened in my extended family. My wife's aunt's husband passed away, and she had no money. The only asset she had was her home. She transferred her home to her 3 children, and one of those children ended up having a heart attack, losing his business, and the creditors attached the home. So in her later years, she lost 1/3 of the value of her assets, and it became very, very difficult for her when she moved into her daughter's house to afford long-term care. So these are the types of things that we try to avoid. Is moving your house to another individual or to a trust, for instance, even necessary? Well, that's a conversation that we have because according to Medicaid rules, the house is an exempt asset, meaning it's not counted as long as you're living there. So there may not even be a reason to transfer it, but that's something that we discuss in our meetings.